The next matter to come before the court this morning is State of Ohio versus Taylor Kepich. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and would wish to reserve that time, if you let me know when you get started, I'm keeping the clock this morning and can keep you apprised of the passage of time. The court's read the briefs and we are ready to see when you are.
Thank you, Your Honor. May it please the court, Angela Killey on behalf of the appellant, Taylor Kepich. For the record, this is Attorney Randall Gray. He is shadowing me on this case pursuant to the requirements of the App.No Bar Association. So I would like to reserve 5 minutes for rebuttal, please. The question presented in this case, Your Honors, is whether the imposition of a maximum prison sentence on a first-time offender is contrary to law and/or an abuse of discretion. And we assert that the answer to that question is yes. If you look at the statute, well, first and foremost, I would acknowledge that there is some law out there that says that if the court actually goes through the sentencing statute, there's a presumption that unless the record indicates otherwise, or that the sentence is strikingly inconsistent with the factors, that it is not contrary to law. It would be our position that in order to determine if it is in fact contrary to law, that there needs to be more than just a blanket statement by the trial court that they reviewed the factors, because if this court looks at those individual factors as it pertains to Mr. Kepich, feel that it is clear that the court could not have considered them because they do not weigh in favor of a prison sentence or at a minimum a maximum prison sentence. Those factors for review come from 29-29-12. First determination is whether this is more serious than what normally constitutes the offense. And we would assert in this position that none of the factors that are outlined by the statute apply to Mr. Kepich in his scenario. When you look at the factors to determine whether it is less serious than what normally constitutes the offense, we would say that the answer to that is yes. If the court had weighed those factors, you would find that there was no serious injury to the officer, although there was some indication of blood on his lower lip by another officer. The officer was in fact able to get up, continue to effect a lawful arrest, and didn't have any medical bills or treatment as a result of this. An assault in and of itself would indicate some injury. It's whether or not that's a serious injury, which we did not have in this case. In looking at whether recidivism is more likely, we're talking about a young man here who has no prior juvenile convictions, no prior adult criminal history, and never had any prior rehabilitative efforts in the community that he could have failed at, which is what the court was supposed to have looked at. None of that is applicable to Mr. Kepich. Whether recidivism is less likely, there was some remorse on the part of Mr. Kepich. In his testimony, he admitted that he behaved inappropriately and that at one point he had wanted to assist the officer, but he was afraid of the taser that was out at that time. He did not actually admit to the offense, but he has never admitted to and wished to preserve his right to be here today. And once again, you look at his record, which is no priors, no juvenile history, and has been a law-abiding citizen for all of his 19 years at this point in time. It would be our position that if the court had actually weighed those factors as it was supposed to, instead of just issuing a blanket statement that it did so, as is the practice of many trial courts, there would be no finding that a maximum sentence was appropriate and that this is in fact contrary to law. If the court feels that it is not contrary to law because of the statement, we would still assert that it is in fact an abuse of discretion, which is the second step in the analysis of this process. An abuse of discretion is unreasonable, arbitrary, or unconscionable. When the code was changed to create presumptions of community control, presumptions of prison, part of that was to have the court look at and determine who really needed to go. We admit that Mr. Kepich is not entitled to a presumption of community control in this instance because of the nature of the offense, but at the same time, I still think that if you look at it from an abuse of discretion, that if that exists in the law, this is the case. And the reality is that we are talking about a low-level offense with a first-time offender, a very young man, and no prior rehabilitative efforts. There is nothing in the record that would justify that. Finally, when you look at 292911B, the sentencing statute also requires that any sentence imposed be similar for similar crimes and similar offenders. After extensive research, I could find no cases in this jurisdiction or the surrounding ones that would indicate imposition of a maximum prison sentence for a similarly situated defendant for an F4 assault on a police officer. And that being the case, we would submit to court that this sentence is an abuse of discretion by the trial court and ask the court to vacate that sentence and remand it for a new sentencing in this matter. If there are no questions, the rest I would rest on my brief.
Thank you.
May it please the court. Evan DiMartino on behalf of the state of Ohio, the appellee, we are asking that this court affirm the convictions and sentence imposed for Mr. Kepich. With regard to the actual incident itself, the record shows that the officer stopped Mr. Kepich for speeding. Once the defendant stopped his vehicle, he was very irate. He was screaming, yelling, saying, "F the police," other disparaging, angry comments. I believe sentencing counsel described the client as being easily agitated. In this case, the defendant got out of his car and over to the cruiser before the officer even had the car in park or was able to radio dispatch that where he was stopped to let dispatch know where he was and what was going on. This officer...
Excuse me. Was there any indication of intoxication or any other circumstances?
Not that...
Okay. To explain the nature of
The behavior?
conduct?
No.
Okay.
Just that he was easily agitated was the only commentary that I recall, and that was at sentencing. With regard to this officer, he had 30 years of experience. He said that this was the first time he felt that he was in danger, that he could be hurt, that something bad could happen. So the defendant got to the officer's window of the cruiser and sensing danger, the officer pulled out his gun. Eventually, the defendant, after saying, "Go ahead and shoot me," being very agitated, very angry, very uncooperative, finally backed up. The officer got out of the car, decided to get out his taser, still feeling uneasy with the situation, didn't know what was going to happen. Again, the defendant's cussing and saying, "Go ahead, I dare you to tase me," just that type of a behavior. It's not a typical, assault on an officer case. I haven't seen anything quite like this in any of the cases I've handled. Certainly with the climate in this country, though, we've all seen these type of things going on. I'm sure this officer was on edge, not just because of what was happening in this case, but just because of the type of climate with the "go ahead and shoot me" and "go ahead and tase me" and "I dare you" type of thing. In any event, the testimony was that Mr. Kepich was leaving, basically said, "I don't have time for this," was not following the order of the officer, walked over to go into his car. The officer followed him. Mr. Kepich turns around and the officer finds himself falling to the ground. Didn't actually see how Mr. Kepich hit him, but he fell to the ground. An eyewitness said that he saw Mr. Kepich strike the officer in the left collarbone with his right hand. So the evidence was that this was a situation where the officer was on edge. It was not a typical traffic stop or anything like that. The court did at sentencing say that he considered all the sentencing factors. The current state of the law is that a trial court judge does not have to indicate the reasons for its findings. The court did say, "I considered all the sentencing factors." This sentence was within the sentencing range. The court found that this defendant put the officer's life in jeopardy or potential for danger because it was right on the side of the road. The officer was on the ground. Mr. Kepich put his own life in danger by acting the way he did and coming right up to the window, causing the officer to pull out his gun, then causing the officer to use the taser. He could have found himself in a situation where he could have gotten shot, he could have gotten tased, he could have ended up getting hit by a car, anything else on the side of the road with the way that he acted. This is also an officer, 3 decades of experience, who says this was the first time ever he felt his life was in danger. The court considered that this defendant has never accepted responsibility, has shown no remorse, and there is this factor of undisputed, agitated, disrespectful, aggressive behavior towards the officer, which culminated in an assault on the officer. So based on the the facts and the court's analysis that it did in fact go through the sentencing factors, the state would argue that the conviction was supported by this, with the evidence, and that the sentence is not contrary to law and not an abuse of discretion. There's nothing further I would rest on.
Okay.
Thank you. I have nothing further.
Thank you both for your presentations this morning. The court will take the matter under advisement and issue a written decision, which will be mailed to both sides as well as posted on our website and the Ohio Supreme Court website.